Debt buyers just bring atrocious garbage, and 9 out of 10 times they're going to win. But when you get somebody like me or you, now that they're in the end of the case, they've got all this nonsense to support. It's a fiction upon fiction. So they're constantly sending me stuff to support something that even a judge says, this doesn't make any sense. I love trials. The number one thing next to death and taxes that people hate is public speaking. I am so wired wrong that I love public speaking. I will sit on a chair in court and watch the judge just come on. Watch him mess around and not, it's 8:30, come on, you said 8:30, we're going. I've actually yelled at judges, just let's get going. I am just nuts. But that's what you want in a litigator. You're not gonna find a healthy person that litigates cases for a living. Hey, Brian Parker coming at you. Another interesting case. This really is close to the bone, if you will. I've tried cases for 30 years. I'm about to go on Monday to a big one. And I haven't tried a case since COVID, because obviously COVID, but you don't try as much the more you're in this business, because people realize if you've done okay, they don't want to tangle with you. But it feels like this one, they want to mess with me just to make a statement. And I've been doing some stuff that they don't like, you know, like following the law and morals and ethics, I guess. I'm just maybe having an opinion of their actions, but I digress. This is, like, love, and subscribe, as I always ask. I'll only be attaching 2 documents to this. One will be an objection, and this will tell you what I'm going to be doing today, an objection to a submission of documents, and my show notes, which are quite extensive. I've had to do a lot of work. The reason why I'm doing a lot of work is when you go into trial, there is a knowledge of the law, knowledge of your case, knowledge of your client, knowledge of the other side. You should know this other side better than you know yourself. But there's also, you have to have edges. I'm not as unhealthy as I used to be, where I didn't live and die on my next case, and I used to go into the fetal position for days on the couch, not talking to anybody if I lost a case. I'm not at that point, or OCD or germaphobe. All that anxiety came, just horrible anxiety comes out of trial work, but I have to psychologically know my stuff. So I'm in the process right now, on top of all my other work, of getting ready, getting my brain ready, lifting the weights, running, blah, 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 doing whatever it takes. So I'm gonna give you a small piece of that, but a most important piece, I'm gonna give you an evidentiary rule that really is pervasive from the beginning when you do your counter affidavit all the way to trial. I'm not suggesting you're gonna go to trial. This is a good little lesson if you do, but you'll see what I'm gonna be doing today in explaining this subject, that it really goes to the heart of what I preach on my channel in Parker GPT. So this is about understanding and defeating MRE, let's say, call it MRE 902.11, FRE 902.11. I put it that way. Back in the day, FRE 902 was created by the federal rules to say, hey, you no longer need to bring a person to come in and avoid evidence issues and hearsay issues and swear that every document is true on the witness stand. The federal rules and then state rules adopted this such that you don't need a witness. You always need a witness in trial to say, yep, that's my document, yep, we own that. So they created a rule 902.11 to avoid bringing witnesses to court. And I say that because back in the day, I'd get one of these cases and we'd go to trial. I go, well, okay, make sure you bring the guy from Chase. And I'm talking to, let's say, for example, LVNV funding that bought the debt after it was sold 10 years ago. Some guy from Chase Bank is not coming all the way to Podunk, Florida, or Podunk, Michigan, or Podunk, Utah, to say, yep, they're right. They're just not. And so you'd go, okay, I'll see your witness then, and you'd settle the case. So 902.11 was the state's attempt, they claimed, to make things more efficient when it was really just helping the debt collector get their documents in. So I'm going to show you how to beat that back today through a real case that I am litigating, going to trial, where this same 902.11 thing is coming against me. I've got to get out of it. So 902.11 is a rule of evidence that exists in federal court in almost every state. That's why I say MRE 902.11. That's Michigan rules of evidence. Obviously this one's in Michigan. It allows business records to be admitted at trial without a live witness. I love I love trials. I'm nuts. The number one thing next to death and taxes that people hate is public speaking. I am so wired wrong that I love public speaking. I will sit on a chair in court and watch the judge just come on. Watch him mess around and it's 8:30, come on, you said 8:30, we're going. I've actually yelled at judges, just let's get going. I am just nuts. But that's what you want in a litigator. You're not gonna find a healthy person that litigates cases for a living. This is veering off. But I love grabbing a hold of witness because I have this ear that I hear everything. And I can it's not good. I'm divorced twice, so let's put it that way. So as long as documents are accompanied by a witness, they're coming in. 902.11 says no longer need to bring a witness in. If you can get the documents in qualified, then you're okay. You don't need a witness. Debt collectors love that. They don't have to prove their case. So what the 902.11 exception, it's an exception to hearsay. It rests upon 803.6. The business records exception, without exception, is everything to a debt collector. 803.6, the business records exception, is the wonderful thing for debt collectors to get evidence in prior to trial. And when trial comes along, 902.11 is their magic elixir that rests upon 803.6, the business records exception. So that's all avoiding hearsay. So 801 hearsay is basically an out-of-court statement offered in court to prove the truth of the matter it says. I memorized it, having read it and wrote it down 1 million times. An out-of-court statement offered to prove the truth of the matter asserted. So a guy's on the stand and he says, oh yeah, John told me. Well, that's out-of-court statement asserted, and they're trying to prove that John said it or John did it. An out-of-court statement offered to prove the truth of the matter asserted. I'm not gonna break all that down and what that all means, but everything is hearsay without an exception, right? So normally business records are hearsay because they are an out-of-court statement. Chase said, yep, we gave it to John Smith, and now LVNV funding says, yep, what Chase said is true. Well, that's an out-of-court statement. They're saying that John owes it because we've got the documents, offered to prove the truth of the matter asserted, that John owes the debt now to LVNV funding. 902 rests upon 803.6. To qualify under 803.6, made at or near the time of the event or from information from someone with personal knowledge. They gotta have personal knowledge of the event, kept in the course of regular conducted business activity. It was the regular practice of that business to make such a record. A qualified witness or certification lays that foundation. The source of the preparation doesn't show untrustworthiness. Really, the evidence rule is all about reliability and trustworthiness. Whether it's a person testifying or a document testifying, it must be deemed trustworthy and reliable, and my evidence professor used to say, it must have an indicia of reliability for it to come in and be held in the way that you want to use it. I, again, have tried probably hundreds of cases for 30 years. And back in the day, I loved these cases because I knew a witness wasn't going to come in and they'd say, oh, we're going to win this case, we're going to win this case. But a witness had to come in and prove the following, these 4 things. They are our company's records. We keep these records in the regular course of business. Yes, these records are accurate and reliable. I have personal knowledge. But now 902 says you don't need a witness, just submit a written declaration. The records are automatically considered authentic. Debt collectors love this rule. So I'm going to present to you today an actual document they're trying to get 70 pages of a weird chain of title in that the judge has already said, you don't have assignments for this stuff, but I stopped getting weird about this. But debt buyers just bring atrocious garbage, and 9 out of 10 times they're gonna win. But when you get somebody like me or you, now that they're at the end of the case, they've got all this nonsense to support. It's a fiction upon fiction. So they're constantly sending me stuff to support something that even a judge says, this doesn't make any sense. So I'm going to trial Monday with documents that clearly show LVNV funding does not own the debt. But because they started with fiction, they have to end the case with fiction. So the stuff that's coming my way, I got a good judge, so that's good. So the stuff that's coming my way and that they've submitted to avoid, by the way, they need a witness. You're gonna see there's 5 entities that claim to have owned this debt, one of which they don't even know how they got the debt. So they need a witness to come and save them. But fiction upon fiction, they're just going on the documents because they love 902.11. So here is how the case started. I'm going to give you a diagram of all the entities that claim to own this debt. Shazam, SoFi Bank sold a debt to SoFi Personal Loan Trust 2023-1. SoFi securitizes everything. If you have a SoFi case and you look at your loan agreement, sometimes it says we securitize this stuff, which is great for me. That's less hoops I got to jump through. But they're also, LVNV is claiming, they then sold it to Resurgent Capital Services, who then sold it to LVNV Funding. However, along the way, we've had a couple of motions to dismiss. And again, remember, it's fiction upon fiction. Another bill of sale popped up that says SoFi Personal Credit or something like that. SoFi Lending Corp showed up. And the judge stopped a hearing and said, well, who's that and how did they get them? And the other side couldn't prove it. This is what's going to trial. So this is the schematic of how this chain of title looks. Shazam, it's SoFi Bank to SoFi Lending Corp, to SoFi Personal Loan Trust 2023, Resurgent Capital Services to LVNV Funding. So at a minimum, they've got to show an assignment specific to my client's debt jumping from 1, 2, 3, 4, 5 entities here, right? There's nothing of that. One of these entities they got surprised by. But the reason I give you that background, you can see how to beat what's called a submission of documents under 902.11. To avoid having to bring 5 witnesses into this case, they submit documents, and that's under 902.11. So how do you break that? You break it using the basic hearsay rule against an out-of-court statement offered to prove the truth of the matter asserted. It's all hearsay unless you have an exception. So you've got to break the exception. So here's what they've presented. They've presented like 70 pages of nonsense, but they have to get these 70 pages of nonsense to be evidence and to be allowed to be proving their case, which they need because they're not bringing a witness. They've declared the truth of the matter asserted this way, Shazam, and that's a declaration regarding records of regularly conducted in activity. You'll notice that my client's name is not in any of this. You'll notice that none of the 5 entities are in this. You'll notice that the signator, Holly Cater, is authorized. We don't know by whom. It says Resurgent ID. There are a number of Resurgent entities showing up in this paperwork. She has to be a member of LVNV Funding, know all about SoFi Bank, know all about Resurgent, but she signed off as a Resurgent ID. That has its problems. Also, look, it says it's subscribed and sworn to me before this September 9th, 2025. Who's signing off to say that she actually, in other words, it's claimed to be notarized, but it isn't. That's a common thing with LVNV Funding. Again, 9 out of 10 of these things are gonna not be defended against. They're just gonna get defaulted. So they throw nonsense at the wall. But then you and I come along and say, wait a minute, the emperor's not wearing any clothes. He is naked. And now they've got to pretend that naked is clothes. So her declaration says the following: I'm a custodian of the records for LVNV Funding. It does not say that. These records were made in regular course of business. What records? It is the regular practice to keep these records. Where? In a garbage bin? But look at the problems now. So there are four red flags that I focus in when I create my objection to this. And you're going to see you have to create an objection, otherwise the stuff's coming in. They're hoping you don't file the objection. So number one red flag, Holly Cater works for Resurgent, a third-party debt collect servicer, and not LVNV Funding. How can she be the custodian of LVNV Funding's records? Number two, we do not know who supplied the records. The original creditor, maybe, but not LVNV, has not signed anything here. Declaration is completely generic. That's about as generic as you could be. It doesn't have any entities. It doesn't have even my client's name inside it. She has no personal knowledge. She wasn't there when the account was opened or any of those entities passed the debt along. There's no mention of an assignment. She's just looking at a computer screen, okay? Number four, it is signed in a way that the documents are notarized, but there's no notary signing off. Let me show that. Shazam, there's that signature again, and there's no LVNV Funding authorization or signing. We're assuming she works for Resurgent ID, but Resurgent ID is not a company. Is it Resurgent Capital Services? Is it Resurgent this? There's like 3 or 4 Resurgents. And again, there's no notary. The original information is hearsay. Someone at SoFi created this. So there's got to be a witness saying, yep, we created that, we created that, we created that, and they don't even have an LVNV Funding witness. This is what I'm dealing with. It makes me nervous because it's so, for lack of a better way, it's in a sense, it's so easy to point it out. Now you get nervous, like the judge is going to be, look, he owes the debt, because you have those type of judges and I've had to appeal them. But here's the requirements for them to get this in, okay? So you gotta look at the requirements to beat them down. Under 902.11, the person signing the declaration must either be a custodian of the records or a qualified person who has personal knowledge. That means they need to actually work for the company, know how the records are kept, and be able to testify about them. Here's how the 8036 business records exception works, all right? It's a 4-part test to get this stuff in. And I'm sorry if I'm boring you, but it'll make sense at the end. Shazam, I'm just gonna do it the only way it can be done. So the declaration must state the records were made at or near the time of the event by someone with personal knowledge in the regular course of business, and it's the regular practice of such records. So here's what Ms. Cater's declaration shows under 8036. The declarant is with Resurgent, not SoFi. She cannot testify how SoFi records were created. She is not able to authenticate the original creditor's records or any of the other entities that I showed you. This affidavit, it's not even an affidavit, it's not sworn, does not meet 8036B business records. So what do you do so the court sees this? Because the court's not gonna, it only gets what you hand it. So here are the grounds where I think I'm going to give you 5 grounds where you can show an objection. Number 1, because this is where we get to the heart of the matter. You look at the foundation and specificity. The declaration is signed by Holly Cater, who identifies herself as an authorized representative with Resurgent ID number. If Ms. Cater is employed by Resurgent Capital Services rather than LVNV Funding, she cannot be the custodian for LVNV Funding. Here's that chart again. There's the 5 entities, Shazam, there's the 5 entities. The affiant must actually work for the company whose records she authenticates. Let me repeat that. For her to authenticate the records, to avoid under evidence rules, under court rules, we want a witness. We all know that. You gotta have a witness say, this happened, that's my document, I did that. You can avoid that if you have a decent declaration under 8036. We do not have anything even coming close to those 5 entities having sworn documents for the Resurgent Holly Cater representative to say, yep, those are good, you don't need a witness. So you object on the grounds of what's called hearsay within hearsay. I love that expression. That's hearsay within hearsay. And that is most prevalently used, is most often used to any debt buyer's documents. Each layer must qualify under a hearsay exception or exclusion. If a statement contains another hearsay statement inside it, it is hearsay within hearsay. So a business record says, customer John Smith told us he paid the account in full. That's 2 levels of hearsay. The business record itself, John saying there's an actual out-of-court statement to the account, and then his spoken statement inside the record. This has to come in under 805 if it meets 8036 and his statement fits another exception, which it won't. In other words, it's like peeling away an onion. Each layer has to be independently admissible. But that's the Achilles heel. So the 902.11 exception to getting records in without a witness, debt collectors love. The Achilles heel, the thing that kills them, especially with debt buyer cases, is they can never authenticate every entity's records that sometimes go back 5-10 years. Their records are just copies of someone else's. They can't even tell you in this case, they can't tell you who created these records. So they have failed to establish a regular business practice. The business records exception exists to admit reliable records prepared in the ordinary course of business. Here we have a generic boilerplate statement and there is no foundation. One of the things in this case, and this is very common, is an objection would be inadequate notice. Inadequate notice means they've decided not to bring a witness and they're going to bring this 902.11 exception, right? So you then get the document so you can go, okay, I'll depose this guy, okay, this is good, you have to be given this, you have to give notice of what they're presenting, not the day before. Here, Holly Cater signed it September 5th, 2025. We'd already determined that we were going to trial back in August. This should have been done like before the case started. We did not receive the declaration until October 5th. It's going to trial next week. Courts recognize that we need time to review and challenge. If you got the notice days before trial like I did, that's not reasonable. So they're failing in all the boxes you need to check off to get these documents in. I had a case once where we got it the day before. We got all this stuff instead of a witness the day before. The witness, the affiant that signed off on it, had died. I'm not laughing at that. I'm like, what are those facts? How is that possible? And the judge said, yeah, but he owes the debt. And was like, whoa, 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 whoa. That's irrelevant. They can't get those documents in without a witness, and the witness died. He said, yeah, we're bringing him in. So I had to get the Court of Appeals involved. They appealed the guy, the judge, and he let them have, yeah, they're coming in anyway. So the second time we appealed it, this is nonsense, the Court of Appeals said, I'm not giving it back to that judge. We're determining that Parker's client wins. But that happens. That's why I get nervous, because I know 2 and 2 equals 4, and yet you'll get a judge with an agenda or laziness or for whatever reason. There's good judges. And this one I have going on Monday is one of the best. Deliberate, reads and thinks, and doesn't take any nonsense, either side. But you have these bad judges, so sometimes you gotta appeal. So you send in this objection to their submission of records with all these different ways to object, showing they have violated 8036 and 902.11. It doesn't stand up. So what's likely to happen with me? I believe the court's gonna go, yep, there's no way this stuff's coming in. You've gotta bring a witness. Well, there is no witness. They will need 5 witnesses to come in. So they're likely to seek a continuance. I know the court's not gonna have any of that. So they're gonna have to trial their case without those documents. So I'm suddenly gonna be whisked back into a room to talk about the case. So that's where I hope this is going, in using the rules that debt collectors love. And I want you to remember these rights. Shazam, you have the right to confront witnesses against you. You have the right to cross-examine evidence, if either through him sitting on the witness stand, I get to tear him apart, or you get to tear him apart, or their documents. You have the right to demand proof. The very genesis of every video, basically, is there's no proof. It's the burden of proof. You have the right to object, as I am doing here. You have the right to appeal. I hope you don't have to exercise that right, especially when you are right. I've been there, done that. But this is how to object to self-authenticating documents in debt collection cases. And I hope it's been useful, not just on the task at hand, but explaining evidence rules. Everything is hearsay unless there's an exception. Here, debt collectors like 902.11 because they can just bring any documents in. You gotta object, and that objection can make you win the case. I'll attach the objection that I supplied in this case, plus my show notes, and I'm hoping that's helpful. I'm hoping this wasn't too tough to get through. Thank you, Brian Parker.